My name is Jerry Elmer. I'm a senior attorney at Conservation Law Foundation. I'm speaking in support of S756. My testimony will be very brief because the entire bill is exactly one sentence long. The bill says that the EFSB won't render a final decision on an application unless it gets the legally required advisory opinions from sister state agencies. When the General Assembly passed the Energy Facility Siting Act in 1986, the law was a two-part bargain. The law took away from local municipalities and state agencies like DEM and Department of Health licensing authority over power plants and put that with the EFSB. The second part of the bargain was those agencies that theretofore had legal permitting authority and was taken away, got to render advisory opinions to the EFSB. I know whereof I speak from firsthand knowledge. We are litigating in the EFSB, and today, 6 of the 12 agencies that were designated by the EFSB to render advisory opinions have told the EFSB in writing, that they cannot and will not provide advisory opinions so long as Invenergy withholds necessary information from them. 6 of the 12 agencies have said we cannot provide the required advisory opinions because Invenergy is not providing necessary information. Passing this bill is not changing the rules in the middle of the game. Passing this bill is enforcing the rule that you enacted, that the General Assembly enacted in 1986, that said you will not get a ruling from the EFSB until and unless those advisory opinions are in. When you passed the law in 1986, you decided that the EFSB should not give a permit without those advisory opinions. And unless this bill is enacted, your intention will be thwarted. Yesterday afternoon in the EFSB, one of those 12 agencies made a filing about his advisory opinion. This was the Burrillville building inspector, who filed with the EFSB a statement why his advisory opinion wasn't in yet. He wrote, the applicant, Invenergy, has never submitted a legitimate plan creating a lot where the Clear River Energy Center is supposed to be constructed. How can he give an advisory opinion? He wrote, as of this date, that date was yesterday afternoon, as of this date, I have not received any information from Invenergy related to my advisory opinion. Building inspector didn't give an advisory opinion because he hasn't gotten legally required information from Invenergy. If this bill is not enacted, you will be allowing any power plant applicant to do an illegal, improper end run around the law that you enacted in 1986. Building inspector says, as to what Invenergy should have submitted to the town zoning board, it has not changed these past 10 months. Nothing new. We are not changing the rules in the middle of the game. We are seeking to enforce the law that you enacted in 1986. Thank you.
Senator Lombardi.
Thank you. Jerry, what, if anything, was Invenergy's response to the lack of advisory opinions from at least a half dozen of the relevant departments?
2 different parties in the EFSB, the town of Burrillville and Conservation Law Foundation, filed with the EFSB motions to dismiss the entire docket based on the lack of information. Invenergy said, well, they filed something, we can supplement information later, we'll give information later. And the EFSB ruled, they said, yes, Under the existing law, we could dismiss the case for lack of information, but technically we're not obligated to dismiss the case. The EFSB was correct about that. The EFSB, under the existing law says it may deny a permit based on lack of information, but it doesn't have to. This law clarifies the intent from 1986 and says, yeah, those advisory opinions really are necessary. The process that the General Assembly enacted in 1986 may not have been a perfect process, and perhaps if I were czar of the universe, which my wife tells me I'm not, I wouldn't have passed the law as you did in 1986. But it is the law we have today, and in order for the process to work, those advisory opinions have to come in, because if they don't, the EFSB's opinion is not fully informed. And importantly, we permit any permit applicant, like Invenergy or another one in 2 years or 5 years, to do an illegal end run around the process. And that's not what the General Assembly had in mind in 1986.
Thank you. Any other questions or comments for this witness? Thank you.
If I may add one thing, I apologize. Senator Nesselbush, when we were here a year ago, you had a concern about an Invenergy-related bill that was, I think, fair, about changing the rules in the middle of the game, that the rules that the EFSB would apply in rendering a final decision might not be the same as the rules that were in effect at the time the application was originally filed, which in this case was October 29th, 2015. Your concern last year, I disagreed with you, but your concern last year was fair about changing the rules in the middle of the game. That should not be a concern with this bill. This bill has the General Assembly saying those rules that we enacted in 1986, we meant them.